This is regarding, my lord, the petitioner is the father of a student of a school. My lord, there is a playground in the school, my lord, and all of a sudden some person came and they want to build a ICDS center, my lord, which is completely illegal, my lord. Already, my lord, gratefully, your lordship.
So, Mr. Advocate General, I troubled you to come in the morning. The temperature is a bit low. But what is the problem I'm telling you? What I'm finding in this determination is the appointment letter issued by respective the different district primary school councils. Their format are completely different. One is not matching with the other. But one thing is common, that all appointments are on temporary basis for 2 years, terminable. If you see any one of the appointment letters, you will find it appears to be a completely contractual basis. But persons are coming for transfer, supposing transfer rule specified that you must be a confirmed teacher. There are two rules was operating in the field. 2001 rules, there is a rule 23 which has prescribed a procedure for confirmation. But the subsequent rule of 2016, there is no such prescription, how this will be confirmed. And you know, the Supreme Court says that automatic confirmation is not. There must be a confirmation procedure. After the teachers are coming, they are stuck on the point that your service is not confirmed, therefore you are eligible for apply for even mutual transfer. Then when I am relegating for them to see what is the status of your confirmation, then and there they are confirmed, they are confirming it. But this is not desire of this court, that on the direction of the court all will be confirmed. Confirmed means whether they have rendered satisfactory service or not. So why it is happening? Why this is a gap in the rule? How it can be met? This is number one. Number two, the district primary councils are issuing even the confirmation. There is no prescription. What should be the format? So what I think, the appointment letter must be in a prescribed form for all. It will be similar to, it is not somebody is writing in a one page form, some other district council is writing in other form. These are the two large issues. If you see and the how this who is a permanent teacher, this has been defined in leave rules. Therefore, I cannot borrow in case of transfer. There is the transfer rule is not independent. Even the act itself has not defined who is a permanent teacher. At the time of retirement, obviously the teacher is coming to the SI and saying that I confirm my teacher at the time of retirement. Possibly he is writing SC, this is a confirmation, or not writing, coming to read court. Please see all these things. How it be? I think that what you say, Principal Secretary Education, if you can take up the issue with the Principal Secretary, because I do not want to give any, take it into the judicial side, because there is nothing, because I cannot direct each and every district council, do it, do it, do it. So see that all district councils appointment letter should be in particular form. The confirmation procedure they should follow in a particular way. After 2 years, this drive should be taken away. Please take these issues.
I'll look into it. When is the matter next fixed?
Mr. Shanal has, and the other aspect is, so for the intra-district transfer, there is a rule. The division bench has said that there is no rule for inter-district. Now, there is a practice procedure prescribed or notified by the board. This practice procedure is of 1991, I suppose, 1991. But after this new act of RT, Mr. Shanal suggested that it requires some upgradation. So these are the areas where it will be looked into, as a holistic look is to be given. In one matter comes, I direct something, it goes. Yeah, I do not want that. Please take up the issues with the board and others so that at least you can apprise this court how it can be meted out.
Primary.
Mr. Biswas and all of you, please assist Advocate General. What are the questions are cropping up in different
But I'll look
matters?
into the rules also and talk to the appropriate person.
Yes, how this is coming in every matter or some, it is not, I'm not able to identify a particular matter where this has been cropped up. So please assist Mr. Advocate General, make him understand what are the, where the rules are being looked into. The, I think that Education Department can notify that this should be the format of appointment letter. Now, at this stage may not be the appointment letter is an issue, but the confirmation must be in this form. And rules regarding, that judgment I will be supplying where the Honorable Supreme Court has held that it cannot be done. It is not automatic. There must be a rule.
But on that, my lord, there is divergence of opinion in the Supreme Court. But there is one view which says that unless the rules provide that if you are not specifically confirmed, you are not a confirmed employee. There is some judgment which says that if it is a person is allowed to work after the probationary period is over, deemed confirmed. There are various.
When you have a scope, when you are getting a scope to make it a streamline, so take that. That is what I am desiring from you.
Very good.
Thank you. An appropriate matter, I may notify you.
Very good. I'll sit with them and then
After the temperature reduces a little bit.
Yes.
Then I will.
It's already reducing.
After that, at 10:30. Thank you.
I'm good. কবে আসবেন সাথে কথা বলুন
the books, entire primary books.
Yes. Next week.
Because
syllabus?
I'll give you. I've got it through my mail, but let me go through it and Malat hand over it. Malat, we asked for the book from the Saraswati Press. It is almost 50 or 58 books. 1 to 5 total.
But classify it.
Yes. 1, 2, 3, 4, 5. I will.
And the syllabus also. I need to get the syllabus first.
I will hand over.
And when ask your president to apprise this court, when it was last upgraded?
Everything I will. I got your lordship, Malat. I will.
Call the list.
Number 1.
For the petitioner, this was the matter where it was fixed for apprising the court whether
is also mutual transfer. Item number 1.
So it is better in this matter I should get the views of the
Yes.
Mr. Advocate General.
this was the matter where your lordship had called for the AG to apprise the court.
So I think that he requires at least 1 week time. So and inform him if he is present in this matter, it will be help beneficial.
Lordship.
Very well. Come at to be mentioned the same place next Friday.
Next Friday.
Place the matter in the supplementary list at 10:30 on next Friday. Inform Mr. Advocate General accordingly.
Yes.
And supply him a copy of the writ petition.
This is my production.
Lordship, the petitioner is a retired primary school teacher. The Lordship, the Honorable Division Bench already held that the persons, the teacher, who has completed the training qualification appeared in 2006, result published in 2011. Lordship, they are entitled to get A category scale since 2006. Now, Lordship, here in this case, the petitioner standing on the same footing. I have annexed the Honorable Division Bench judgment and Honorable Single Judge's order, identical orders. That petition, that similar type of teachers already granted a category scale with effect from
But
2006.
that was not a precedent.
This
The
is a,
judgment was not a precedent.
now this is petitioner is also same identical fact that petitioner also completed the B.Ed training, PTTI training, appeared in 2006, completed in 2011, same batch. Now petitioner here in this case, petitioner already returned. Now my Lordship, the entire service books will be returned to the DI that there is the clarification of a category scale, so that my documents is returned from the
That notification you have got, the latest notification,
a category scale.
and
Yes,
it should
yes,
not.
yes. I have annexed this, sir.
No, it should not be reopened. There is one notification. Someone showed me that there is a, if there is any lack of, where is the division bench? Show me that
Yes,
division bench.
kindly come to the Honorable Division Bench order. That is page 177. Sorry. Kindly come. Yes, page 80.
Which portion is relevant?
Lordship, we have Lordship, the paragraph 7 and 8. Seven last portion entitled to get a category scale. Now, relying upon this order, Lordship, the Honorable another learned coordinate bench passed order considering all objections whether the candidate entitled to a category scale from 2006, that is page 88. Task form. Paragraph 25.
Page?
Page 94.
'94.
Page 94 of the writ petition.
88 is a single bench order.
88 starts, its end on 94. Paragraph 25.
I think there is a notification. Who is appearing for the, you are appearing for the?
I am appealing for the state, my lord. My lord, I have handed over one, my lord, the order, my lord, passed by the division bench, my lord.
Car order it.
Whereby it is saying, my lord, paragraph 3 of the order, my lord. Since the single bench has directed payment of A category scale of pay after the last date of examination, we feel that the writ petitioner is entitled to an interim protection pending the instant appeal. It is not in dispute that the writ petitioner is getting A category scale of pay, and the only point involved is from which date he is entitled to get the same. In such view of the matter, we stay the operation of the order by which the writ petitioner was directed to be paid A category scale of pay from 17 March 2019.
This is different aspect.
17th March is possibly the date of appointment. But the issue is almost matching with it. Where is the DPSC? Who's DPSC?
No, my appointment 2002.
That last notification, there was a notification.
Last notification, so far the A category scale I have annexed. That is
Where?
for the 2013 notification.
No. Latest notification.
Lordship, we have already returned on the basis of this.
Where is that?
DPSP apprised, my lord.
DPSC.
No, Lordship, several.
Which DPSC?
This is Birbhum DPSC.
List of the
No, Lordship, 96, 98, similar identical matters already A category scale has been granted.
Birbhum. Sumita Sen. Mr. Sarwar Jahan.
Lordship, but Lordship, Mr. Jahan, learned advocate, appeared in this matter. Lordship,
Let me understand. We have made DPSC party.
Yes, I have served.
Title to appear. Service in my court. Service is to the lawyer, not to the DPSC directly. That is the whole name.
No, lots of issue has already
Let him
been
come.
decided.
Why are you so much agitated? Let him come.
But I don't know. Also, page 96, 97, identical.
I will apply my own mind. I don't go by this. I will apply my own mind. I know that there is one notification which has been clarified that issue should not be reopened. There is one notification.
Lordship, kindly come the notification by which this type of petitioner has been granted A category scale. Yes, Lordship, I have annexed also this notification. Kindly come page 69. This is the 4th March 2030.
Send someone to inform Mr. Jahan.
Lordship, this is the last notification of the 69. Grant A category scale of pay to the primary school teachers.
No, thereafter, another notification, it specifically said that this issue should not be reopened. At what stage you are stuck now?
Lordship, I appeared in the PTTI examination.
No, where your pension papers are now stuck.
The concerned DI, kindly come to the last page 107. Only for the issue that A category scale has not been calculated, so my entire documents has been returned back. That is the from sub-inspector school to the chairman. The office of the undersigned would like to inform you that Raufar Ali, that the petitioner, such and such, pension file previously has been directed by the DPPG with the following remarks. The teacher appointed on 3rd April 2002, that is before 31st December 2005, completed PTTI training in the year 2011, subsequently completed 1-year beach course 2014, may be reviewed in the light of para 2 of GO number such and such 4th March 2013, which has been complied by the applicant Raufar Ali and Lordship such and such. As per the memo dated such and such, DPSC Birbhum, I disputed for 1-year PTTI course as an in-service teacher for the sessions 5-6, but the final examination of the said course was pending due to the court matter and the examination held in 2011. As per the memo number such and such, have enrolled the 1-year beach course for completion of 2-year DLED, and the said course was completed on 23rd April 2014. Please refer to clause 1 and 3 of memo number such and such for clarification A category benefit. I also informed that EPPO issued on the similar ground previously for application such and such, but on such and such pension file again objected by DPPG with the following remarks. Relevant GO, since education department in support reply may be sought. I would like to inform you that the teacher
The
past
SI,
PTTI.
the SI has sought clarification. Who is for the state? SI has sought for clarification from the chairman, DPSC chairman.
Mrs. Sen is appearing, Malad. I'm told, Malad. I had a talk with Mrs. Sen, Malad, Smita Sen. Malad, the Lordship can take it a many day, Malad. Take instruction from the DPSC. Malad,
No DPSC instruction necessary. What the the SI is seeking a clarification. This was sought for in April 2024.
what is the present status? Whether
No, he
this
should give
clarification was,
immediately,
is it
so
clarification?
that he get a cause of action to come to me,
Yes, yes.
because he has approached this court on this premise that whether
This clarification was at all answered by the
no, not
SI
at all, not at all, not yet answered,
No,
not yet answered.
I'm
No, no,
very
answer to the SI or not, that, Malad,
No.
suppose the council has answered to
Mr.
the
Jahan,
SI.
you appear for the Birhum DPSC.
Along with Sumita Sen.
I
Yes,
had a
but-
talk with Mrs. Sen, Malad.
But please clarify, if you see, share it with Mr. Mukherjee. Come to page 107. He was a teacher who was appointed on 3rd April 2002.
ক্লারিফিকেশন চেয়েছে স্যার কাছ থেকে, এটা কাউন্সিল দিয়েছে, যদি না এলে জানতে পারে না।
So let us take instruction from our council.
No, see that this is the letter in April 2024 is still pending. He is not getting pension. Whether he is at all entitled to a category scale. If first of all, I cannot substitute your view. Chairman, please say your SI is seeking, SI of a circle is seeking your guidance on the claim of the petitioner. Please clarify. Clarify it within 7 days. Instead of giving it to him, put it before me so that in one shot it can be cleared.
If not already clarified.
No, he is saying no clarification.
There is a till date.
But this is something not issued by the Sabines SI to the chairman. I don't know at present whether that has been replied to the SI or not.
What he is saying, not replied, he is
How we come to
No,
he's not getting pension.
That maybe his apprehension, or let us come with the instruction.
You come.
If not, I shall come with the clarification.
Yes, come with the clarification, go through it under such, this
yes.
is another notification somebody had showed me that yesterday I have disposed of, that this A category scale of pay, B.Ed, which course not completed, it cannot be reopened. That is a notification, latest.
Latest notification, yes.
There is a latest notification.
Notification.
Also,
What is that notification?
my
What it
humble-
was?
That already who are enjoying, that cannot be questioned.
Cannot be questioned. Then that matter is settled that he was enjoying a category scale of pay.
the petitioner.
Huh?
No, category scale has been given.
Never
No.
given. Then if it is given today, you have some, you will be getting some, you must have some area.
Yes, from 2006, I am entitled to get a category scale as per the order of the division
What-
bench.
What he is relying on, Mr. Jahan, he is saying that he has completed 1 year bridge course.
Lordship, even the honorable division bench has directed who has been appointed prior to 2005. He is not required to, Lordship, they develop his bridge course and not required to complete
Forget about
bridge
that. Now,
course.
what is the factual aspect? What you did?
Lordship, my case before your Lordship, that I was appointed in 2002. I appeared in the PTTI Lordship training course, 1 year bridge training course in 2006. Examination conducted in 2011 due to the different court cases. Tulsi Boxi's case. Now, Lordship, we filed a writ petition that this type of teachers
No,
entitled
you
to-
completed 1 year PGT?
Yes,
You completed the
yes,
course. Then
2011 I have completed.
2000 you completed.
1 year, Lordship, PTTI training completed. Now a writ petition was moved. It is ultimately went up to the honorable division bench. Honorable division
No,
bench. Yes.
therefore, the factual aspect is that he has got his 1 year PGT, what is called
PTTI training.
PTTI training.
Primary
course.
teachers.
So with this qualification, because the time He applied within 1 year, for 1 year, got it, it was delayed, ultimately 2011 he completed. So whether he is entitled to agree. If he is entitled, then process your pension paper on the basis of his admissible scale of pay, and he must have accrued some area.
Yes.
You have to pay that. These are the two issues.
Yes, this is my prayer before you.
Ashun.
And Lordship, Mr. Jahan Laner advocate appeared in this matter. All before division bench or honorable single judge.
Let this seek the
This
instruction.
writ petition is not with me. For the first time, I'm accepting. So, Malord, let me come back with the proper instruction.
The petitioner is a retired assistant teacher of a primary school, primary school under the district primary council. Stop. The petitioner is complaining that due to the complaining that the retired that he has not yet received his retirement benefits including pension have not yet been disbursed. The issue regarding entitlement of the petitioner to get A category scale of A category scale of pay is pending consideration before the chairman of the said council.
Date of result.
The sub-inspector of school of the circle, relevant circle, sought for a clarification from the chairman of the said council regarding entitlement of the petitioner to get the A category scale of pay. The same since has not been replied. The petitioner is not getting pension and other retirement benefits. Stop. Mr. Jahan appears on behalf of the said council and place accommodation to file a report on the issue. Let such report be filed on the next date of hearing. Pension matter, January. You come with a clarification if he is entitled to, but pendency, please don't defer it. Then process the event. In the event, the chairman of the council finds that the petitioner is entitled to such a category scale of pay, he shall proceed to prepare the pension papers for disbursement of same in favor of the petitioner, notwithstanding pendency of the petition.
Great. Prosenjit Mukherjee.
I don't know.
I am for the petitioner.
What is
The matter relates to non-payment of family pension. Petitioner is the unmarried daughter.
which DPSC?
Malord, Paschim Medinipur. Malord, the page 21, your lordship.
Service?
DPSC has not been made a party, your lordship. DI has, and DI already forwarded my pension case before the DPPG. Page 21.
No one is appearing for the state. Well,
Page 21, your lordship. Recommending family pension in my favor. The district school has already forwarded my pension case before the DPPG.
And since my lord 9th May 2024, the pension file is pending before the DPPG and no PPO has been issued till date.
Bring one panda from corridor, state panda. Otherwise, the puja will not be completed. The blank, and you have to take the risk of task of rather sending it to DPPG. No one is in this room for a state.
Definitely, my lord, appearing. Though I appear, my lord, but someone is appearing, my lord.
Inquire from the GP office.
My lord, Mr. Mridmoy Kumar Sahu and Tonusri
you know
Banerjee. They are
inform them so that the appropriate direction can be passed and can be disposed it of. Pass over. Inform them. it. Doctor.
My lord, I'm for the petitioners.
And for the board lashon.
Safety of my lord, the petitioner is a cancer patient suffering from 2019. She had undergone surgery, and 2021 she got appointment in the primary school. Now, my lord, she made an application
Before
Yes. Now there are 2 rounds of litigation previous to that. She applied for transfer because she's still undergoing treatment at Tata Memorial Center. She's undergoing
you
cancer
were
treatment.
suffering from when you took the job.
Yes, I'm coming to that. Now, my lord, she prayed for transfer because she's still undergoing cancer treatment. She's going on. Treatment is going on. And long follow-up treatment is to take place, which is as per the Tata Memorial advice. Now, my lord, she made an application for transfer. It was not allowed since 2 years. She has only completed at that point of time 2 years, not 5 years. So she moved a writ application before the Honorable Single Bench. Honorable Single Bench was pleased to observe that it is the pre-existing disease for which it cannot be allowed. Rightly so. Now the matter went up to the Honorable Division Bench. The Honorable Division Bench was pleased to concur with the view of the Honorable Single Bench, but took a more humanitarian approach since she is undergoing the cancer treatment. The Honorable Division Bench said that if CMOH permits, then the DI will take a step in regarding her transfer.
CMH permits means?
If CMOH after going through the medical report thinks that she is required to take transfer because of her medical condition and the ongoing treatment, and if CMOH allows it, then the DI will take
kindly
steps.
come to page
May I
69,
just complete? May I
division.
just complete? Please have some patience. 2 minutes. Then the DI records everything and said, I am not the appropriate authority. Board is the appropriate authority. So he passed an order. So I approached the board that, see, this is my medical condition. The Honorable Division Bench has said that if CMOH allows, then I may be considered for transfer, and CMOH has allowed it. So I moved an application before the concerned board that kindly consider my transfer since I'm undergoing the treatment. I may be given transfer from Paschim Bardhaman to Bankura.
Home district.
Home district, because this traveling and this staying far, it is difficult because, my lord, the treatment phase is more painful, possibly, as I was told by her that regarding the operation, this treatment phase is more painful and she needs to go again and again. So, my lord, that was
Your review is pending.
No. That was not entertained. That was the previous learned advocate was it thought it fit to move a review application. The Honorable Division Bench did not interfere into that. And if your lordship kindly takes the Honorable Division Bench's order for once, that is at
Where the school is? Bakura.
Paschim Bardhaman.
Paschim Bardhaman.
Paschim Bardhaman. My lord, kindly page 69
Pritam Chaudhary.
is page
And then she resides in Bakura.
Bankura. My lord, page
You want to go to Bakura?
Bankura, my lord, since the treatment is going on, my lord, page 69 is the Division Bench order. If your lordship kindly takes page 71 paragraph, that is there, the observation of the Honorable Division Bench at paragraph number 3 at page 70. And the CMOH observation at page 72. CMOH had already verified my medical condition.
Okay, sir.
Page 72 is the CMOH report, which was there. The DI is littered at this page 73. My lord, kindly take the last paragraph. It says,
CMH at
CMOH at page 72.
last line is surplus. Doctors also came to learn about this Uchosri.
No, it is no. It goes through mentioned Uchosri only. For Uchosri specifically,
On to page 72.
yes, last line through Uchosri portal. Your lordship. Yes, it happens. The DI sends to the CMOH referring that these are for transfer through Uchosri portal. That's why
Achha.
special board is
Your application was through Uchosri.
yes, it was through
It is
Uchosri.
you are pursuing the earlier application or is a new application?
No, it is the initiation from that application only. It is
No,
going
this
on.
decision maybe, but is it a new application?
No. So from Uchosri, I have annexed the status also, page 64.
So it is still you are pursuing that application?
Yes. Because I'm continuing 60. That transfer application was made through Uchosri, not allowed. Single bench from division bench to DI. DI now writes that I am not the authority. It has been sent to the board to take decision. It is pending. The DI has already sent
But
it to
this
the.
sending to board is not a no concept in Uchosri.
No, because what happened, my lord, in my humble submission, it ought to have been placed before the honorable division bench that the board is the appropriate authority. Maybe due to this is sincerity interest due to inadvertence, possibly it was not placed before the honorable division bench. Division bench directed the DI. Usually, what happens in the secondary. So possibly due to some, I don't wish to
But
enter
you
into
have
that.
the application after the all
Yes.
dismissal cannot route it through that and reach to board.
No, rightly so. Because the honorable division bench thought it fit to direct the DI, possibly the honorable division bench
But
was
the
not.
DI will consider the DI
No,
can
DI has
do the
no authority. DI, that's why sent it to the board, who is the
how
appropriate
he is
authority.
sending to board under the Uchosri.
No, I'm not under Uchosri, as per the order of the honorable division bench.
Now you are breaking the Uchosri.
Lordship?
So long you are pursuing with Uchosri, now you are coming out of Uchosri.
No. That is continuing.
And how it has reached to where is the bridge from DI to board under Uchosri?
There is no bridge. DI has rightly sent it to the board. That's it. Though there is a direction upon me.
Just tell me.
Yes.
In Uchosri,
Yes.
how there is a bridge from board DI to board?
No, there is no bridge. It is channelized through the SI, DPSC, then it goes to the board. Now, since honorable division bench possibly was not assisted properly, so this has come. I do not want to enter into that because I was not there. So the honorable division bench directed the DI to look into it. Now, DI has rightly said, I'm being very candid before your lordship, rightly said that I'm not the authority board. So it has been sent to the board ultimately to the appropriate authority. It is pending before the board. So a decision may be taken on that matter, for which I have come before your lordship.
See, I have yet to receive any instruction from this.
Is the DPSC?
I have the DPSC.
Yes.
What is the number of students in the school where she is the teacher?
I am a surplus now. It is recorded in the court's order, division bench's order. It is recorded.
I initially said that I am yet to receive any instruction in this matter.
Get the instruction.
Today itself I shall take the instruction. Let it appear on Monday so that.
Not Monday, but
Tuesday,
the number of whether she is at all a surplus teacher or not. If she is a surplus teacher, then the first question comes in that whether she will be exploited in the same district or in a different district. Then the question comes, surplus must go to another school. So prayer of transfer would be allowed. But whether it will be according to her choice of home district or not, that depends upon actually whether her the illness what she is now portraying
kindly considers
is of that
health
much
condition.
that she cannot do that. Usually what has been written by CMOH, this is really a matter of concern, no doubt about it.
Well, page
But,
50 is the Tata Memorial Centers.
but whether that, because ultimately she will be in Bakura, it is not that she will be going to near to the Tata Memorial Hospital.
No, the
Ultimately,
support
she
from
has
the
to-
family is needed, my lord, for her to take the medicine and the treatment. Support of the family is needed in this
So,
situation.
of course, there may be,
So kindly. my lord.
but you are in Tata Memorial. So from Bakura to Tata Memorial and Paschim Mednipur to Tata Memorial, the same thing.
No, she goes with her husband. Husband's presence and the family member support is needed to take
Husband
her.
works where?
Husband works where, that I need to check up. It is possibly there. And the other family members are also there to support her.
Husband works where?
Let me check, my lord. কি দেওয়া আছে? Husband কোথায় আছে? দেখিনি।
What has been stated?
That the distance between the workplace of the petitioner and
Distance we know.
Yes.
No,
Yes, yes,
it is
yes.
not
40
written.
40 kilometers from this workplace, distance between the spouse and the petitioner. So he stays at his home and she's at Paschim Bardhaman. So my lord,
No, that is what I know.
mhm.
That where the husband is in Paschim Bardhaman.
No, he's in Bakura itself. 40 kilometers distance. He's in Bakura. So she needs to come back to Bakura to her husband, and so that she can be accompanied by the husband or any other family members to take the medical
No,
checkup.
you are in Bakura.
My residence is in Bakura. I am teaching at Paschim Bardhaman.
Paschim Bardhaman.
Yes,
So husband is also in Bakura.
also in Bakura.
What he does?
He is, my lord, I'm just telling you, lordship.
You want to go your matrimonial home or your own house? Paternal home.
My lord, I'm just giving the reference.
Clarify.
This is the matrimonial home of the petitioner with the husband, and other family members are also there to support her.
Make it clear.
Mhm.
You want to be nearer to be in the matrimonial home.
Possibly matrimonial home is matrimonial home.
To be with your husband in at this situation.
Yes.
Develop your writ petition.
No, this is the petrol. I'll
Where
come
is
back
your
with
averment?
no, I'll come back with instruction whether
Averment.
no, it is not there. Averment is not there.
So it may be an additional prayer for you. My husband resides in Bakura.
That's
I
what
want to go back to my matrimonial home so that my husband can take care of my ailing condition.
that is I've stated.
Where is that?
Yes, I've stated.
Where have you stated
Yes,
that?
I'm submitting. Oh yes, yes. Now this voter card also shows that the same address with the
Averment.
yes, averment.
Voter card. Who is the advocate on record?
I'm the advocate on it.
So,
My lord, kindly take the paragraph number 3 that I have stated that the
if
petitioner.
it is not clearly, then I will reject here and now. Otherwise, I will give you the opportunity to bring it on record.
Yes, I'll take
Because-
the opportunity, my lord. I'll take the opportunity. Kindly allow me to give a supplementary affidavit. I'll give all details of it. I'll take the opportunity.
Because the policy and procedure also prescribes
Yes.
that the practice would be to bring both of them together in a place. Now, in the backdrop of her suffering,
Yes.
whether that can be considered or not,
Document is a petition of the yes, I'll bring with kindly allow me to leave to file a
service
supplementary affidavit. I'll
file on behalf of the petitioner be kept with that.
That's it.
Mr. Lahiri, learned advocate for the petitioner, pays leave to file a supplementary affidavit to the writ petition. Such affidavit be affirmed within a week from date. Copy thereof is supplied to learned counsel for the appearing respondents. Stop. Mr. Pritam Chaudhary appears. Learned advocate for the district primary council. Bidhum, na?
No,
Paschim
Paschim Bardhaman shall take appropriate instruction on the prayer of the petitioner for general transfer to inter-district general transfer.
on special ground, medical ground.
Stop. You express your opinion.
My lord, I have got the instruction. My lord, it was with me. Yeah, he's an assistant teacher. Husband is an assistant teacher in Bankura itself. I had the.
Where is the environment?
I'll make it. I place it.
Smart boy.
I'll place it. I'll place it. I'll place it.
The 2002 rules. Just one paragraph. Rule 4 lordship.
It is annexed with the writ petition.
4 lordship and the buttons.
It was a dual rulta. It got amended, I believe.
Rule 4 lordship.
How it applies to him, to her?
He just submitted that in the learned trial court, what I observed, the 5 years is not completed for a general transfer. Since he has joined 2021, 5 years before completion of 5 years.
Under the rule 2002 rules.
Lordship, amendment is also there. Kindly go through
7 years.
5
Rule
years.
4 lordship.
2 years,
2
4B.
years. Then it was amended to 5 years. In the amendment in 2021, that is also there.
What are you
For
submitting,
general
sir?
He is asking for.
What are you submitting, sir, after this so long a time?
No, it was submitted in the trial court only.
No.
That went up.
You should point out to the learned single judge.
That has been pointed out.
You should point out to the division bench that 2002 rule has got no manner of application in case of inter-district transfer. That you have shown to me. In other matters, his matters I have directed to consider. I should not have directed that because the practice procedure has been prescribed. 2002 rule has got no manner of application in respect of inter-district transfer because sub-rule 2 of 1 says these rules shall apply to teachers including head teacher for the purpose of transfer from one primary school to another within the jurisdiction of a council. This is intra-district transfer rules. And the practice and procedure that has been laid down from deriving Rule 8. That is why I am waiting for Mr. Shanal's reaction. Yes, Rule 8. The transfer is, this is the 2016 rule, I suppose.
That, yes.
That deriving that, the board has framed practice and procedure. That you have to follow the practice and procedure. Possibly in the practice, there is a practice that has to be followed. The board has decided to follow. The husband wife should be brought in one place. This may be the inuring to the.
Regarding this interdistrict.
Why don't you see that?
Seriously, I don't know. It is nowhere available. That was possibly withdrawn. It is nowhere.
Which one withdrawn? Which one was withdrawn?
Possibly not withdrawn. That was because state government issue a notification in 2021 or 2020 that home district they can apply for the home district.
Well, your lordship has considered the amendment of Rule 8. Page 50 of it, my petition.
No.
Sees once. It is written there.
See this. Okay.
Yes, it is written. It is written. This rule has to be followed. Yes. Principles and procedures for transfer of teacher non-teaching staff in a primary school between two primary councils. Yes.
Understood?
Yes.
Shortcoming of sub-rule 2, 2002,
Yes.
that has to be covered by this practice and procedure. One practice is that they should be brought in one place, like any other rules of any other
Central
organization,
Yes.
to bring in one place.
Yes.
Now, 2002 rules prescribe the limitation. There is no such prescription in
Page
2000.
58. Kindly see the amendment. It says, I'm reading.
Page 58 what?
Of the writ petition, the amendment.
Amendment of what?
Rule 8. Now, kindly see what it says. Inter-council transfer. While considering inter-council transfer in accordance with the provision of clause K of section 19(1) of the Act, the board shall mutatis mutandis follow the provisions of these rules, particularly in sub-rule 3 of Rule 5 of the rules.
Therefore,
These rules, man, 2002 amendment rules. Kindly take page 58. Page 58 for once, madam.
This has been framed how? If you come.
This is mere guideline. This has no statutory force.
Why? It has. Because if you got the following are the principles and procedures of transfer of teacher and non-teaching staff the primary school within the jurisdiction of one primary school to a primary school within the jurisdiction another primary school council set by West Bengal Board of Primary Education for the purpose of clause K, subsection 1 of section 19 of the Act itself.
Right.
Now, if you go by Rule 8, what Mr.
Page
Sannal was.
58, kindly takes page 58 for once.
Wait.
This is mere principle. SOP.
Now, in case of inter-council transfer, the council shall follow the principles and procedure of the board in accordance with the provision conferred with now Rule 8, what I am reading.
Yes.
Now, this is the principles and procedure.
Yes.
Deriving the power from there, read with 19K,
1K.
this procedure has been
Now
followed.
kindly take page 58 of my writ petition, the amended rules. Now it is a statutory notification having overriding effect over this procedure. Page 58, amendment to Rule 8.
Now, these are you have given to me. These are the amendments in 2002 rules.
Yes.
These are the amended.
Yes.
The amendment has not been incorporated in this
No.
book.
Kindly
Now,
see.
these amendment says for a Rule 8, substitute the following.
Substituted.
Sub-rule C.
These rules.
Now, if that be so, how can you reconcile with sub-rule 2 of Rule 1? How can you reconcile sub-rule 2 of Rule 1?
This is the definition clause.
Sub-rule 2 of definition 1. These rules shall apply to teachers, including head teachers, for the purpose of transfer from one primary council to another within the jurisdiction of a council.
Your Lordship is referring to 2.
1, the Rule 1, sub-rule 2.
Sub-rule 2. These rules.
এই ফাইলটা দিচ্ছ না কেন, যে ফাইলের মধ্যে সবগুলো আছে? এই বিশ্বজিৎ কোথায় গেল?
It is in my writ petition. This is there. All are annexed. তুমি 2002 এর অ্যামেন্ডমেন্টটা তো ওটা অ্যানেক্স আছে, আমার সব পিটিশন অ্যানেক্স থাকে। Now, my lord, if your lordship takes the short title of the statute, the rules may be called the West Bengal Primary Education Transfer of Teachers, including Head Teacher Rules 2002. So it covers teachers and head teachers of primary. There is no specification. Otherwise, it would have been mentioned for intra-district transfer. It is not. The rule says now.
Sub-rule 2.
Yes, I'm talking about the heading 1. 1.
Not very well.
It covers
the name only.
Name covers everything. Now, it says that it only is applicable to intra-district within the council. Another within the jurisdiction of
name cannot override the sub-rule 2's clarification.
Starting
No.
from 1. Yes, I'm starting from 1. Now, these rules were brought under the 1973 Act 2A.
No, whatever, in which way you go, even if the procedure and the principle to be followed,
yes,
that also
that
prescribes.
should be harmonious. Even if that should be harmonious. I'm not saying that it is not to be taken into consideration, but in addition to the statutory provision, this SOP can be.
No, this amendment when comes, how can it be reconciled with sub-rule 2 of 1 and
Yes,
amendment of 8? How can it be reconciled with?
Possibly there is an answer to this.
Work on it, work on it. Yeah, if you come to the principle, that's what I was looking. A primary teacher who is married to a person who is compelled to live in a distant place from where daily communication to her present school of posting is not permissible, desiring to be transferred to the place where she can be live with his or her wife and husband. This is the only one of the objectives sought to be achieved by the principal, right? So if that be the objective, then a teacher who is suffering from cancer,
Yes.
she wants to go to the place of her husband. That is coming within
That is
this.
coming.
So you smart boy, you have
I
not
take
seen
records.
that.
No, I
Where is the pleadings?
that I have stated
Why it
that
is lacking? File afresh.
no, my lord, I will cancer patient, my
Why-
lord, kindly do not. I will come with the supplementary affidavit. Your
Why
lordship has
this
already.
fresh?
No, no.
Because of you.
No, my lord, then I'll take records of
Because-
section rule 8. I will take records. My little smartness would refer to rule 8 then. It says, and your lordship has not struck it down yet.
No,
Lordship needs
no.
to struck down rule 8. Then.
Rule 8 says that you have to follow this procedure.
Mutatis mutandis
Muta
of
applies.
these rules.
2002 applies, but the practice procedure specifically says that in a case of husband-wife, the attempt or the endeavor should be to bring them both together.
My response is, my lord, I have not taken because in my understanding, it does not have any statutory force. Now, this amendment has statutory force 1. Now, it is for the court to iron out the creases. If your lordship considers it for humanitarian approach, your lordship kindly refers to that and pass the order.
8 is saying that, but you cannot say a practice and procedure that has been laid down on the basis of the unamended 8. Unamended 8. When it was
do not
framed,
know when it came to effect.
No, this is C.
There is no
By
notification now.
There is the notification.
May I just
This was in 1991.
1991.
1990 notification number 2309192.
Then 2002 rule came into effect.
Then 2002 rule
Yes.
came in. Prior to that, 2001 was there.
So after 1990, the statute comes into effect.
Therefore, when
Yes.
it has been sub-rule 2 was there.
Yes.
One sub-rule 2, excluding the operation of 2002 rules in the field of inter-district transfer.
This SOP was not even under any statute. It was a mere notification. Then 2001, 2002 comes into effect. The statute itself.
Mr. Lahiri,
Then 2021.
Mr.
How am I
Lahiri,
supposed to refer that, my lord?
Mr. Lahiri, a notification deriving its power
Yes.
from 19K of the original act via Rule 8, unamended Rule 8. It has something more than a mere administrative notice.
Possibly rule 8 was not there in 1991, subject to correction, my lord. It is of 1991.
No. Rule 8 was not there.
Not then how did he derive the power
No.
to come into effect?
No.
I
This
pose
was
question to myself.
19K original.
70.
Original 19K.
That's the general
of the
rule.
Act, general
Now
What
this is
was
the
19K?
specific.
What was 19?
19K was the
was the
powers
Act,
of the
Lordship,
board.
1973
1973
Act.
Act
was
was the
amended to
act,
2021.
1970. No,
Power to
1973.
make rules.
Power to make rules. That's a general provision of law. Now this rule is a specific provision of law.
Mr. Lahiri exercising that these principles and procedure have been laid down. Source is 19K. Can you say this is merely
No, source is 19K. Absolutely.
This is only merely an administrative notice.
This is the general provision 1973. Specific provision is
You
this.
file for fresh.
No, no, kindly, I'll come with this supplementary. Kindly. For this one statement, I am making the oral submission, but I'll come with some. Not.
Why you don't know that?
Punish me, my lord. Impose cost upon me. Any punishment I will take, but not for a cancer patient, my lord.
Sir Chaudhary, you get an instruction.
I'll come back with the supplement. I'll leave supplementary. I'll come.
কোথায়
Just to
লিখলাম
state where
রাখলাম?
it works.
And shall file a report. And shall file. And shall ঠিক আছে দরকার নেই। জানুয়ারি
পশ্চিম বর্ধমান আসানসোল
আরে গড়িয়া থাকবো রোজ আমরা একসাথে গাড়ি করে আছি
February substanding. And so far the other district, Bakura is a party here.
Bakura is not required. Board. No, board.
Made him a party.
Very well. I'll make.
Again,
No, Bakura have no.
because you have to go to Bakura.
Yes. Board
You-
has.
he has to take
I'll make them party. I'll make them party. Leave may be granted. My lord, my ekhuni dinam kore deব.
this quality section.
No, I'll do it, my lord. Kindly. I have not. My lord, punish me. My lord, but it was a very interesting point we have taken.
না না পশ্চিম বর্ধমান না
না, করেছে, করেছে। But it's a very interesting point your lordship has rightly pointed out. It never came into my mind.
পশ্চিম বর্ধমান you want to go to পশ্চিম বর্ধমান
Bankura.
বাঁকুড়া বাঁকুড়া who is for বাঁকুড়া
Bankura,
ভাস্কর প্রসাদ বৈশ্য
I'll serve him. I'll make him a party.
হাসপাতাল নীলাবড়
নীলয়কে দিয়ে দেবো।
leave is
এই পয়েন্টটা
কি লিখেছে
ইন্টারেস্টিং পয়েন্ট, ভেরি ইন্টারেস্টিং পয়েন্ট। হ্যাঁ, এটা কিন্তু খুব ইটস ভেরি এনজয়েবল পয়েন্ট,
supplementary leave
ইন্টারেস্টিং।
a further leave is also granted to the learned petitioner to add
This is general rule.
the State Primary Council, School Council, Bankura as party respondent to the petition and to effect service of notice upon the said added respondent. Serve upon Mr. Boisho.
Leave may
Add
be
it.
granted, my lord. So
Add
that
it, add it, add it.
Lordship is keeping it on.
Monthly list,
monthly is January.
January,
My lord has
Transfer.
directed me to the supplementary affidavit
7 days.
7 days.
And service upon all appearing
Yes,
councils.
yes, absolutely, my lord, absolutely. My lord, it was a very interesting point. This 19K, it was
Interesting point.
very interesting point.
It is
Affidavit of service be kept with the record.
wait a minute.
And she's a confirmed teacher, my lord. She's got confirmation.
I have talked with learned advocate for the state, my lord. He is not available today. So lordship kindly
Who
keep,
is the advocate?
my lord, Mrinmoy Kumar Sahu.
Need not appear. Need not appear. Let his name be struck down from the state roll. I am advising the legal remembrance. Why they take the state brief if they do not want to appear? Huh? Give me these two persons, na? Neither of them are available.
My lord, another, my lord, Tanisri Banerjee, she is engaged in court number 11. My lord, she is saying that the brief is not with him, her, my lord, today.
So let them not to be a state advocate and tell them after 12 o'clock their name should be struck out. At least the junior advocate ask her to come. Senior advocate's name I'll be advising legal remembrances to struck his name from the state roll. Advise him to come, her to come.
Well, my lord.
Yes.
My lord, I am appealing for the petitioner.
Last occasion, I beg to appear on behalf of the respondent number 4. That is
ECL
officer.
matter,
Yes.
ECL matter.
Last occasion, they relied upon the judgment of Mohadev Banerjee. My lord was kind enough to instruct, direct us to go through that judgment. My lord, may I just place that judgment for my lord and may I just go through it once?
What was the case before it?
That is a separate case. It is a case wherein these teachers were appointed in the prior to 1968. My lord, we find that at paragraph 2. In 1968, these teachers were appointed by collieries, by schools maintained by private collieries. Thereafter, my lord, in the year 1973, this nationalization came into effect. These teachers continued. Now, one fine morning, the Coal India decided not to engage them anymore. So now, under such circumstances, they filed this matter before the learned court below. Their contention, the issue which was raised by them, or the issue which was before the Honorable Supreme Court, was that what will be the effect of Section 14 of that Act 1968, and there was an amendment 1973, and there was an amendment. What will be that effect also? My lord, will find that at paragraph 5. Their court held that no, these people were appointed or were taken over prior to the act coming into force. At the time when that act came into force, there was no such policy or there was no such amendment which came on at a later stage. So by applying a amendment which came retrospectively, you cannot deny them the benefit of employment. Once it was taken over at the time of nationalization, they continue to be your employee. This is the crux of that Mahadev Banerjee's case. If my lord may take note of, I will just indicate the paragraphs for my lord's consideration. The facts has been deliberated in paragraph 2.
But here in this case, the difference is that he was never been appointed or never been taken over his
Never. He was appointed, his own statement is at paragraph 2. He was appointed in the year 2000 by a privately managed school, wherein ECL is providing at that relevant point of time grant in it. And why this grant in it? So that the I was having a conversation with my colleague, but why this grant in it? Because villages are there, colliery areas, many villages are there, miners are there, so that for corporate social responsibility, everybody has this responsibility to give that. These schools are maybe
one word, there is no employer-employee relationship.
And that has been held, rightly or wrongly, my lord, by the Labour Commissioner also, where he has raised grievances. Maybe the Labour Commissioner has stated that I do not have the jurisdiction to decide, but Labour Commissioner, after taking into account all the records produced by him, produced by us, has held that there exists no employer-employee relationship.
Oh, I was a bit want to get a response from you in this Mahadev Banerjee's case.
I'm grateful.
Now, what I'm getting here,
my lord,
the petitioner was engaged by
issue 2000. My lord will find that at page 2, paragraph 2.
Page 11, my lord.
Page 11 is engagement.
A permanency. Page 11.
And there were, I was, if may I,
this document is by the managing committee of the school,
yes,
not by the Coal India.
Lordship.
Right?
Right. Now, you'll also kindly come to page 17, my lord. 17. That is a document, my lord. The school is in Eastern Coalfields Limited. Premises.
17.
17, 17, my lord.
What are allotted?
What are allotted? The school is in 17 minute.
What are allotted?
With reference to a letter such and such, information understand we choose the new school building, Miller. 17, 17 Miller. Water allotment is 16. That 17 Miller.
Okay, this has been page 17 is the quarter allotment.
Next page, next page,
What do you want us to say?
Only I just private committee managed school, Mahadev Moira Junior High School and Shishu Vidya Niketan, 10-minute distance, sir.
আচ্ছা ঠিক আছে বোঝা গেছে
Next page, Miller. After the allotment of quarter, next page, Miller.
17.
Yes.
The next page what? Handwritten page?
No,
Page
Miller.
number 50, my appointment details.
Done. 17 Miller.
17 I have seen.
Secretary.
Secretary Shishu.
Secretary, yes. Done.
What do you want to say by showing this document?
My lord, the school is in the Coal India premises. Eastern Coalfield premises. My submission before your lordship is the judgment your lordship seen, my lord. At page 8, paragraph 8, it has been distinguished that there is relationship, and their judgment was passed in 2008. 2008, taking into all rules and regulations therein, and
but you are not a teacher when the colliery was taken over.
That may be, but that
you were not a teacher when the colliery was taken over by the
paragraph 8, minute will you kindly page 242.
হ্যাঁ হ্যাঁ ওইটাই দেখালেন তো
242,
আগে।
minute paragraph 8, minute.
Yes.
কথা বলছি।
You are not a teacher when the coal mines were nationalized by the Nationalization Act 1970. What is the full name of the act?
My lord, coal mine nationalization, and my lord, we'll find that at the very paragraph 2. Paragraph 2, the Coal Mines Nationalization Act 1973. It is 1, 2, 3, 4.
Yes. Coal mines nationalized. But the existence of those schools under the private collieries were taken over under this.
And those were present, those
The
employees.
learned judge was of the opinion, since the schools were taken over along with other assets of the coal mines, so the employer-employee relation does exist between.
By dint of section 14, my lord, take note of paragraph 9. This was prior to amendment. And what happens after amendment, my lord, will find that at paragraph 11.
Employment of certain employees to continue.
Yes, my lord. That is prior to amendment of that. Then kindly take note of paragraph 11. This was the 11 was the case which was made out by Eastern Coalfield.
Whatever may be, the right flows from section 14
Section
of
14?
the Mines of that. In that case, but here a private setup school where the Coal India was under the obligation, rather some voluntary act in that sense, decided to provide grantee aid. Since this is a zero enrollment school, has decided not to continue with such grantee aid.
That will also,
you cannot have.
My lord, will also find that page 29, the status of the school.
Of the writ petition.
It is Shishu Vivekanand Niketan School. This is a inter-communication which they have annexed. This has reference, may I read, my lord? This has reference to a letter dated such and such regarding non-functioning of 3 schools of Moira and Andhra Colliery, that is Shishu Vidyan. I'm just relying upon Shishu Vidyaniketan. Shishu Vidyaniketan School. My lord, admittedly the petitioner is claiming to be the teacher of Shishu Vidyaniketan. So it is non-functioning. No student, 0.
Very sure.
I have one order from this honorable court. Similar type of, and a special officer was saying.
We have appeared in this matter that travel to the Supreme Court, travel to the division bench, my lord. It is pending before, my lord. There are many. It has flown from that to many because our country.
What is the matter about?
The same, some individuals claiming themselves to be the employees of ECL has saying that we are the employees of ECL, kindly regularizes our service.
And then
it is pending, Miller, not disposed of.
2016 they filed. Thereafter from
3 matters are analyzed the hard matter.
No, 2. One matter, the matter of Mahadev Banerjee has been tagged with that matter. My lord, then what has happened? My lord, there were some directions. We have filed a report. In report, we have categorically stated that no, these are not employees. We are granting it. We provided that. So the court was of the view, no, you provide some salary to them. They were running schools. Some of them are running schools. Special officer was appointed. We have taken an exception. My lord, those exception, what we have taken in that exception, that is, I do not want to say, but what has happened, the special officer visited the school. It was a specific direction of the court that it will be a surprise visit to ascertain what is the actual happenings. the special officer visited the school with the teachers who have filed the writ petition. And
Where is the appointment? Where is the order appointing a special officer?
that is, now they have to.
Show me that order.
And more, what has more happened, I just did not want to say because this was.
Of the order, Mela. Page
And
three,
what?
top. It is 31st March 2023.
Then
What happened? We were directed to deposit some amount with the registrar, and the direction was given that this amount should be disbursed for their salary. Now we made our necessary research. We brought to the notice of the court that some of them, the petitioners, has expired long back. They never brought to the notice of this honorable court that these petitioners have expired. They have drawing the salary. They drew the salary, and
these two matters.
These two matters. And after that, when it was Justice Mantha, this was pointed out. Justice Mantha, when inquired from them, what is their explanation? Oh, we don't know. Petitioner number 1 expired. Nobody, the petitioners don't know, the other petitioners don't know, and they are trying to create an image.
Money you have paid.
We have paid. Registrar has registered. They have collected the check from the registrar. Report was called for. This was the situation. This was we faced.
Public money. These matters are pending still.
They have not taken any step for mentioning of these matters.
It is mentioned. I have instruction that is mentioned. Before you
We have not received any notice. I am personally appearing in this matter. This matter, I am representing the respondent.
Yes, sir. They mentioned before your lordship.
My lord, I am talking about those two matters.
These matters is analogous to this.
I don't follow these two matters.
Yes.
How many matters are pending? Get it done all together. Otherwise, this will.
Yes, ma'am.
Rabindranath Roy and others.
Notice this, Lord.
Ishwari
Lal. Ishwari Lal has expired. Expired. Money has been collected.
Now, these are the two matters pending.
And along with this, the then single judge they relied upon that again that Mahadev Banerjee's judgment. One fine morning they relied upon. And the judge was directed to tag the records of that Mahadev Banerjee matter. So that Mahadev Banerjee matter is also tagged with along with those two matters.
So Mahadev Banerjee has been settled up to Supreme Court.
So the judges of that at that time, the relevant, the learned judge, the honorable judge was of the view, let I go through the files of the Mahadev Banerjee.
Hey, you know.
All teachers.
These two matters I cannot take up because of this group 2 classification.
It is they are trying to
no relevance with it.
They are trying to create. I'm forced to submit this, my lord. They are trying to taking advantage that I am not getting any salary. No records are being produced. Nothing is being shown. Because of the honorable, we all try to help them, but they are taking advantage of that.
My lord, please allow me. Allow my lord.
There is no termination. Or
No. Private committee. Ek minute, sir. Moira Junior High School and Sisuvidya Niketan both are private committee managed school. Here in the
also attain the age of super.
both are private committee managed school, sir.
They are admitting they are privately managed.
No. Here, sir. Judgment টা এখন পর্যন্ত judgment হয়েছে, sir. Moira Junior High School এ এখন পর্যন্ত, sir, page number 23 kindly check করুন, sir. Private committee managed school এ এখন পর্যন্ত আছে Moira Junior High School.
There's a zero enrollment school.
Sir,
these two schools are not zero enrollment.
This is a record.
না, sir, এইটা বলছি, sir, as per AB Brahma, as per A.V. Brahma, Member Secretary JBCCI, 8 October 96, implementation instruction, clearly
This is
implementation
a zero
instruction.
enrollment
No,
school.
no, sir,
Akim.
50, sir,
এখন কোনো
50,
স্টুডেন্ট তো নেই সেটাই
sir,
জানতে চাচ্ছি।
implementation is 54,
These
sir,
two schools have students. You don't have any student.
from 24, Your Honor.
Then the 24 is closed from 24. Ligun, the
Sir,
petitioner.
kindly, sir, please, sir. एक শুধু আমার appointment শুধু দেখলেন, sir. All are in respondent are here. Agent.
একটু আমাকে কপি দিন একটা, এটা তো নয় নিশ্চয়ই।
Yes, you are appointed means what? The school managing committee has been pleased to appoint you as a temporary school managing committee.
Letter is permanent.
Does it?
Oh,
Sir, not sir, please, sir. Here's the next page, sir. Please, sir. Please, sir. Please, sir.
next page.
Every sir detail of the my appointment from the ECL approval. Then I am starting the work in the school. And this is the ECL. এটা স্যার আছে যেখানে সব অফিসাররা আছেন কমিটিতে। It is the sir since 1974. It is school is the established for 1974.
How the fund has been utilized. They have to file a utilization certificate. Take the document.
What he is writing, secretary,
Yes, sir.
the
Everything.
school is writing to Amarendra Kumar, you are the petitioner, that this is the letter of Shishu Vidya Niketan. When the Coal India has said that you are an employee under them, show me a paper.
As per implementation is 54, teacher exist in the Coal India.
Take your seat.
কোল ইন্ডিয়া যে
হ্যাঁ হ্যাঁ
অ্যাপয়েন্টমেন্ট দিয়েছে কোথায়?
হ্যাঁ স্যার, হ্যাঁ হ্যাঁ স্যার।
যে আপনার নেই তো, আপনার লোক কমিটি দিয়েছে।
এক মিনিট স্যার।
I don't have that much time.
প্লিজ স্যার, আপনি যদি শুনবেন না স্যার, প্লিজ স্যার, এইটা স্যার
Do one thing.
প্লিজ স্যার,
Whatever document you want to rely on,
স্যার স্যার
because you know that personally I understand the anxiety. He should not be felt that he has not been heard. So whatever document your client intend to rely on, first give copy to him so that he can get the chance of analyzing all these things.
ওকে স্যার।
Okay.
I'll let it after.
Oblige.
January monthly list.
Great.
আই এম গেট টু সব কপি আমার
হ্যাঁ ঠিক, সব কপি আছে আমার কাছে।
Any paper, don't try to put it before the court directly. Give it to him first, let you go through and check up the records of those, whether this was group 9 or group 2. If it is group 9, I will bring it to me.
Yes, yes, ma'am.
Oblige.
Grateful, ma'am. And we will also try to produce, my lord. These are what is grant in it? How this has
No, this is no way. He wants to show some papers, you go through the papers. And please assist this
Absolutely.
court. These are the all irrelevant papers.
Absolutely.
Show me a piece of paper that Coal India has recognized you as an employee of them, not via media. That the school has sent this name to the Coal India. Coal India has confirmed you, not this. কি বলছো? বাইরে নিয়ে এসো।
And for the petitioner, my lord, this is an intra-district mutual transfer, my lord, within district Paschim Bardhaman.
Or I appear for the council.
But
Petitioner number 1 is confirmed and 2 has not received the confirmation yet.
2 has not yet. So first of all,
Take one instruction and file.
Asul. Individual service filed on behalf of the petitioners be kept with the record. Petitioners are assistant teachers of primary schools under the district primary council, school council, Purbo, no, Paschim Medinipur, Paschim Bardhaman, Paschim Bardhaman.
We are appearing for the state in this matter.
The service of the petition number 2 is yet to be confirmed. As such, he is not eligible for eligible to apply for such general service. When he was appointed?
My lord, the petitioner number 1 was appointed in the year
No,
2000.
no, two. One is confirmed.
2 was appointed in 2010.
Yeah, apply for such? You know, the petition number 2.
Petition number 2 is yet to be confirmed.
No, this petitioner number 2 was appointed in the year 2010, but his service, but he is yet to be, his service, he is yet to be a confirmed teacher. As such, is not eligible to apply for the general transfer under the relevant rules. Stop. The chairman of the council is directed to file a report as to regarding the status of status of confirmation regarding the as to why the service of the petitioner has not yet been confirmed. Stop. The said report shall also disclose as to how many teachers' appointment are yet to be confirmed in the said district. January.
Well, I have already instructed the chairman, Malad, as per your lordship's earlier views, that we need to prepare our list so as to disclose everything before your lordships. He is on it, man. Grateful.
But Mr. Chowdhury, not in that way that I am directing that you will confirm.
No, no. Absolutely. Absolutely. I get your point. Malad, we are appearing for the statement that we have got. Grateful.
Procedural.
Not I beg to appear for the petitioner.
About the statement.
But here's the epic of stories.
About the statement.
Well, this matter relates to selection process 2009 under Howrah DPSC. In one such matter, your lordship has directed the Howrah DPSC to file a report disclosing the particulars of the appointments given pursuant to the direction of this honorable.
Appearing?
Sure.
Where is he?
Lordship engaging another court. Lordship kindly take it up not today.
Why not today? He has not come. But there is one order regarding.
Yes, my lord. The order was that to disclose the particulars of the appointments that has been given pursuant to the direction of a coordinate bench of this honorable court, my lord. That item, it's appearing as item number 268 of monthly list of December, my lord. The principal matter, my lord.
Have you got a copy of that order?
Lord, I have had phone, my lord. Lord, I may supply the hard copy, my lord.
So you also got appointment by this direction, or you participated?
No, my lord, I participated in the selection process, filed this writ petition after the cutoff date of 31st March, my lord.
Oh, that was the cutoff date.
Yes, my lord. That was a similar matter in Promethean also, my lord. In that matter, your lordship had directed the DPSC to file a report disclosing the
So
particulars
writ
of the
petition
appointment.
filed beyond cut-off date. So the principal matter is pending.
It's appearing as item number 268 of your lordship's monthly list.
Page 55 of this order, my lord, a rider has been given.
But that issue has been
19.
That issue has been settled, my lord, in that order.
How it can be? No one has challenged this order, my lord.
This is not on the challenge.
Well,
Paragraph 19 is I have considered it.
Yes.
Now,
yes. Your lordship was of the view that your lordship is not binded by the judgment of the coordinate bench
I
of this honorable court.
understand, but maybe I said that I may also extend the time.
Yes, my lord. That was the opinion, my lord.
That does
every
not
time-
mean, my lord, that floodgate will be open.
Not floodgate. It is full gate is open. There is no barrage.
Nothing.
Everyone can.
That is the reason, my lord, this barrier has been given. Because all on a sudden, my lord, the flooded of matters.
Like Lordship 2016, still now 2024 filing.
If you think it another way, somebody could not come in time. You'll be deprived. So either they will get or no one will get. Very difficult situation. They can legitimately extend it, but I cannot extend it in that way. Let us see what happened to this
Yes, my lord.
matter.
This item is appearing as item number 268 of the monthly list of December, my lord.
Now let this matter be
Let this-
decided. Then after this
Well,
decision,
let this matter appear in the monthly list of January, my lord.
yes, this will appear. Acha.
Lordship, may I copy please? Sir?
Affidavit of service, yes, serve copy.
Okay.
Okay. Affidavit of service filed on behalf of the petitioner or petitioners.
Petitioner, my lord.
We kept with the record. The writ petition. No. The issue which has been sought to be canvassed in the present writ petition is also under consideration in another writ petition. Stop. No, stop for now. And a hearing of which since has been fixed. Now, which is appearing in the combined monthly list of this court, answer to the issue in the said writ petition would determine the fate of this writ petition. Therefore, hearing of this present matter is adjourned for the time being. Let it appear in the monthly combined list of January 2025. Let us see that what happened in that matter.
Deeply.
Let's say I am appealing for the petitioner. This is for transfer.
Transfer.
I am working in the Julian Circle of Murshidabad district under Murshidabad Primary School Council since 2010. And now my parents all are old and ailing, and I have only person to look after them.
Where do you
I
want
am,
to come?
Lordship, I want to come my residential place, Dhulian Raghunathganj Circle.
On the same district.
On the same district. I have made also.
What is this number of students in your?
Lordship, it is 100, 1,100.
1,100.
1100, my lord.
1100.
Student in yes, my lord.
This primary school.
It's a Dhulian area, my lord. Their private institution are not there.
Oh, nice.
Through SSC portal,
How many teachers?
Only 4 permanent teacher and 2 para teachers.
So shortage of teacher, huge
Yes,
shortage of teacher.
teacher.
What are you doing? Send teachers over there.
But rationalization is
You have prepared your
almost. Monday I shall hand it over to you.
so hand it over so that the appropriate teachers can
Yes,
be
yes,
fed over there.
That should
Surplus teacher must go there. Issue an administrative order of transfer to that.
I shall
Now,
hand
1100 student, 4 teachers, what they will do? Monday, place it in the supplementary list. Order lagbe.
Good.
Come with that.
I shall.
For the time being, you may not get the transfer, but you will do some good for this school. Some more teachers will be coming.
But my ailing parents are suffering, Lordship.
The students are suffering.
Lordship, I know, Lordship.
Yes. Lord, I'm for the
Let it be out of
petition.
this liberty to mention 2022 wrong question, Lordship.
Wrong question, na? Out of list, liberty to mention. Hey, Sandeep. Pending repetitions on is dependent upon the outcome of the other repetition on similar issues. Therefore, matter may go out of place for the time being. Liberty to mention after the decision on the said pending repetitions. देखिए कमेंट लिस्ट दाओ देखिए দুটো রাখি এটা দিকে আছে 40
I am for the petition.
for other side.
But I have served on earlier occasion. It was affidavit service has been given to with this.
Which GPSC?
But it is a inter-district transfer from Alipurduar to Purulia.
Both of them party.
Yes, my lord. I have served.
Inform the advocate the কে আছে
পুরুলিয়া হ্যাঁ তুই অ্যাপিয়ার করেছিস
অ্যাপিয়ার করলো সেন্টারে হয়তো কপি চেয়েছিলাম
Oh, Purulia and Ratul Vishwas, state.
I'm for the Purulia, my DPS led by passport.
Where is Mr. and Mrs. Chatterjee? Bring them. I'm coming at 2 p.m. একটু দেখো কাজগুলো করে আসি Inform Alipurduar there is no council, na?
Practically, my lord, in Alipurduar, what I have, my lord, informed, what I have been informed, that one Bikramjit Ghosh is appearing before the circuit bench. Since it is a new district, my lord, no one appears before this Honorable High Court. But since it is an order of the board, my lord, we can challenge it here. And now what happens? Jalpaiguri is earlier occasion. Earlier occasion, Mr. Robin Pal, who sat in court number, bar association room number 2, your lordship knows it better than me. He usually appear for Alipurduar. Now
Alipurduar
said,
Jalpaiguri undivided district.
At that time, undivided. He said, no, I cannot appear because they are not giving me that. That is the main.
For Jalpaiguri, he can appear.
Jalpaiguri, he can appear. He appeared on behalf of Jalpaiguri.
But the district
Alipurduar, since Bikramjit Ghosh, before your lordship knows lordship knows about Bikramjit.
He appears for the
Alipurduar. He appears for DPSC Alipurduar.
Okay,
Your lordship kindly allow me that the matter could be taken up after summers. Then I can inform him through mail that matter is a you can come on online. That I can.
Very well, not today then.
your
Next time you just make them
I can
understand. Inform him.
And my lord, then my lord, 42 is also, my lord, though your lordship just succeeded. 42, it is a South Chobis Pargana to Purulia, inter-district. If your lordship kindly take the matter also, my lord, on only not today, your lordship kindly take the matter.
Very, very.
on
These two, 42 is also not today.
40 and 42.
40 and 42.
Great.
At 2 p.m. I'm coming.
Password matter item number 3.
Who is that?
Lord, I have again talked with Mr. Mrinmoy Kumar Sahu. He said that he is suffering from fever. That's why he has not come to court today.
And the other,
And the other, my lord, first half, she said that her matter is going on in court number 11, and even in the recess time, she is not responding, my lord, my calls.
Very well. Mr. Chattopadhyay appear. I am recommending to LR to delete rather scratch their name from the state roll. What is the name? Naam likh dao to.
Mr. Mrinmoy Kumar Sahu and
Write it
Ms.
down.
Tannusri Banerjee.
Write it down.
Not known face.
ফোন করলাম অনেকবার
ফোন ধরুন না।
LR এর কাছে এই অর্ডার জন্য
Yes, madam. I'm for the state in this matter, madam.
Where is your affidavit of service? Mr. Chatterjee, take care of this brief. Affidavit of service filed on behalf of the petitioner.
Unmarried daughter, family pension.
Be kept with the record. The state is not represented. Mr. Kalyan Kumar Pandal, an advocate for the petitioner, was directed to inquire from the office of the government pleader,
No.
who pleader, as to who are the advocates been engaged on behalf advocates engaged to represent the state in this matter. Mr. Panda, after taking Mr. Panda informs this court that he came to learn from the office of the government pleader না বন্ধ করলে কেন কে দেখে অনলাইনে আছে কিনা one Mr. নাম দিয়ে
Mrinmoy Kumar Sahu.
Mrinmoy Kumar Sahu and one Miss MS Tannusri Banerjee are have been engaged by the state to represent have been engaged by the state are the advocates are the learned advocates engaged to represent the state. Stop. None of the said advocates appear on call. Stop. It appears that the said advocates are not interested to represent the state under circumstances. This court engages Mr. Arindam Chattopadhyay and Ms. Lilika Chatterjee, the learned advocates on the state role to represent the state. Stop. The legal remembrancer is directed to remove the name of the aforementioned two advocates, remove the name of ওটা পরে এনগেজমেন্টটা পরে দেবে অরিন্দমদের এনগেজমেন্টটা পরে ওই নাম দুটো দেওয়া হলো তো তারপরে লিখে দেবে directed to remove the names of the said two learned advocates from the state panel. Stop. এরপরে engagement. However, under such circumstances, the court engages. বলে ওই দুজনের নাম দাও. Their appointments be regularized. একদম শেষে লিখবে copy of this order be immediately communicated to the legal remembrancer of landed কথাটা বসিয়ে দিও LR এর আগে and to the landed government leader yes, what happened?
My lord, petitioner is the unmarried daughter of a primary teacher, your lordship.
Family pension
Family
payer has been
pension,
reached
page
up to the
21,
DPPG.
your lordship.
Is pending at the end of DPPG.
DPPG, lordship.
So you get the report from the DPPG.
Or why not kindly direct the DPPG to
Get a report instead of this. You know,
this is the final
prayer,
stage. This is the final stage.
the prayer of the petitioner for family pension on the death of
Father of the petitioner.
on the father of the petitioner, comma, and an assistant teacher of a primary school.
My lord.
Is pending.
Head teacher, your lords. Head
teacher of a primary school is pending at the end of director of pension, provident fund and group insurance. The respondent number
2, your lordship.
2 herein. The said respondent is directed to file a report regarding the issue on the next dated hearing, January 25, unfinished pension matter. Mr. Chattopadhyay, get it done.
My lord, my lord.
সেটা করে পাঠাও
The matter will appear.
জানুয়ারি পেনশন ম্যাটার এই দুটো নাম ঢুকে রাখো Mr. Chattopadhyay, henceforth, whoever will be showing such attitude, their name should be removed from the state roll.
I will convey my lord's view to the learned.
In convey it to Mr. Roy,
Yeah.
GP, and
Yes.
others.
I will convey.
Combined monthly list, 41.
Carry on. এই পাঠিয়েছো এই সৌরভ মিত্র
Now for the petition. My lord, there's an application, offline application made. She's a surplus teacher in the school. So, surplus teacher.
within the district?
My lord, from Uttar Dinajpur, she prefers to join to Hooghly, DPSC Hooghly.
Difficult.
If there are vacancies, my lord, there are vacancies in.
But you are a surplus teacher in a district. That districts need to be first to be catered.
If her service is not required, my lord, in that
then
case,
then this can be.
my lord, kindly, your lordship has already disposed of such matters by directing the concerned board. But my application,
if this can be done, it can be done within the
Yes,
district.
Secretary West Bengal Board of Primary Education. Where is your report?
Lordship, unless the district says that whether the candidate
I understand, but this was initially get the report from the particular concerned district. Already direction is there upon it. Dinajpur is a party.
Uttar Dinajpur is party.
No, I know the earlier concept was because this board is to be approached. But after this now, in any event, 2 district primary.
Uttar Dinajpur and Hooghly both are
Uttar
led
Dinajpur
by
is party.
Mr. Basumulli.
Yeah, so Uttar Dinajpur is party. Respondent.
And Hooghly, where you
Mr. Basumulli.
Mr. Basumulli is appearing for
they
both
are
the
not a
districts.
party, na?
Hooghly is not a
Because
party.
why?
Yeah,
Uttar
understand.
Dinajpur.
You will inform whether there is.
Yes, and whether any school is over there, it will be easier for you to get these things cleared from here in one
From the board's office, it can be done.
Lordship,
I
board
think
is
what
overburdened,
they
Lordship.
will- Why they will write a letter to those two council for you?
Mails are usually sent.
They,
mails.
while they will do
There is-
that.
Boards
They
are
have
already
helped-
overburdened, Lordship.
Ultimately, they
Highly
need to talk to
appreciate.
both the
District-
DPSCs. Ultimately, they will have to.
Ultimately, let these things would be done as per
Very
this
well.
procedure.
Very well, very well, very well.
Leave is granted to the advocate for the petitioner to add district
Your
primary,
Lordship.
the district primary council,
My lord, Mr. Bosu Malik appearing DPSC, my lord.
Uttar Dinajpur and
Uttar Dinajpur.
the other one,
Hooghly.
এই
Hooghly.
হুগলি হয়ে দাঁড়ান তো দাদা
No.
my lord, both are both DPSC are
I know, but he's not a party.
Ah.
I'm
There was a direction by Lordship on the last occasion to file a report by the board.
now the board. Let these. I'm deferring the filing of report of the board. Ultimately, board will file the report on the basis of the reports of these two primary councils. So you file your report independently.
my lord, previous occasion, my lord, I was filed, my lord.
No, no.
My lord, in this matter.
For
এই
this
মামলাটা
case.
করতে হবে। Yes, my lord, yes, my lord. I will.
ঠিক আছে?
যদি সারপ্লাস হয় আশেপাশে কোনো খালি থাকলে সেটা বলে
As party respondent to the writ petition. Copy of the writ petition be served upon Mr. Bhaskar Prasad Boisho, London Council for the Bosu Mollik.
একটা copy
Subrata
আছে।
Bosu Mollik, London Council for the said added council. Stop. The DPSC Uttar Dinajpur and DPSC Hooghly are directed to file separate reports regarding the prayer of the petitioner for transfer. Stop. January month list.
Indicating the vacancy position. So it will be more specific.
What they will write. What they will write.
Because at
Let
times
them
the
apply their own mind. If the court is wanting report on a transfer matter, then what the court
Your
is
Lordship
looking
has
for.
seen what kind of reports come before your Lordship. Many
What
occasions.
kind of persons are running this kind of shows?
That's the reason.
That's the reason.
Grateful, Lord. Month list of January, my Lord, under the heading transfer. Under the heading transfer.
Yes, Miss Sreyoshi, come forward. This is the model order you have given to me regarding this refund of the, this is the amount to shift from CPF to GPF. All the model orders, the concerned employee could not exercise his option because he was dead. But here in this case, notification came in 2014, he died in 2016. How can you say he could not? This is regarding Prabhavati Maiti. What I am getting from the record, died on 4th, the husband died on 4th January 2016. The notification was of 13 June 2014. So he had a chance to exercise option. He did not. It is not a case he could not. Therefore, why should I allow her widow to exercise that option? I am not signing it. Ask your senior to explain the
Lordship,
situation.
kindly fix it Monday, Lordship.
Monday, I don't know. Monday দেওয়া যাবে না. First of all, ask him to explain it on Monday. Then whether I will bring it on the list or otherwise it will be dismissed. I will think that.
My lord, item number 43, my lord. I'm led by Mr. Bosu Malik, my lord.
43. What is this?
Last, my lord, last.
Oh, acha.
Dinajpur and Hooghly.
Appear. Come to court.
Yes, my lord, come to court, my lord.
Ask him to appear at least once.
Yes, my lord.
Have I seen him? Yes, today he has appeared.
Yes, my lord. Grateful, my lord.
44.
My lord.
Mutual transfer confirmed mutual inter.
Initially, writ application was filed by two petitioners for mutual transfer. Subsequently, I filed an application for addition of party. They are claiming minister amongst the three.
Huh? Who has applied?
Yes, the coordinate bench passed order to that effect, Kindly see my application, first, then
Who is the application for addition of party?
one of the candidates.
You are representing him also. Two candidate petitioners. Can one
Well,
listening? Two PT applicants.
one applicant.
Oh, this is one. Oh,
Regional-
Sanaj Khan.
Kindly, page 13 of my application for addition of party. Page 13, 1-3. But I have prepared a table, Malat. This will be, Malat, that will be clear, Malat. All are confirmed in service, Malat. Their service has been-
Same district.
Yes, same district.
Malda.
Same district.
Malda, same district.
Who is Malda?
Abhishek Prasad. Malat, I saw.
Ask him to come. Then I need to know from his view about your prayer.
I will inform. I will inform.
Well, ask him to be present.
I have asked. I have asked. This is my
Abhishek Prasad ask Mr. Prasad to come. Inform. Send you any of junior. Send
just
anyone.
now.
The petitioners and the applicant of the connected application can one of 2024 are praying mutual transfer are assistant teachers of different primary schools under the district primary council Malda. They are paying mutual transfer amongst themselves. The chairman of the said council is directed to file a report on the said prayer of the said teachers.
All are confirmed in service, Malat. I have to annex the documents.
Five. That's what I find. Confirmed teachers. No, when I confirmed are confirmed assistant teachers. First line is given. January monthly list. But where is Mr. Prasad? He must be knowing.
Send my clerk to inform you.
লোকটা অভিষেকের নামটা দিয়ে appear করিয়ে দেবেন. If not, copy not sub the copy of the application, read petition and the application, both.
Read petition he has received, Malat. So for the application, I must submit. Malat, matter will appear on Malat.
January transfer matter.
Safety of
45. Amongst 3% mutual transfer within Purbo Bardhaman.
Same order? Yes. Who is Purbo Bardhaman?
I am appealing for.
File a report?
Not sure.
আগেরটা যেরকম করলাম ওখানে খালি অ্যাপ্লিকেশন থাকবে না লিখুন পিটিশন all are confirmed teachers
All not received confirmed.
That I am to give report in terms of the confirmation only, in respect
or
of
not
that, but
unless it is you are not sure you are confirmed or not.
Petitioners have been confirmed. They have not received the letter of confirmation.
A letter of confirmation has not been issued.
Riya Ghosh.
Na, 45.
The petitioners are confirmed assistant teacher in different schools under
55.
district primary council Purbo Bardhaman.
তাহলে ঠিক আছে।
Confirmation hasn't been pleaded in the petitions as well. না, জজ সাহেব বলছেন যে petitioner confirm তুমি বললে। They are also not sure, I believe.
No.
Let us
We have,
submit a
we have
report and
stated that
according.
we have 2 years of confirmed continuous service.
Are you sure the confirmation has been issued?
It has not reached us, my lord.
But you are aware that you are confirmed teacher.
Yes, my lord, I'm working for so long. That
is not then.
I have not received any confirmed.
Revolving in a circle.
Black and white is
Let us
No, I have
give
not
a
received
report.
any.
If they are confirmed, then this court may pass necessary.
Then when you can inform this court?
Your Lordship, as already we have initiated that general report, we have directed them to prepare. This thing, I believe, we'll get it by next week. If your Lordship, because your Lordship is keeping these things after the vacation.
Petitioners are assistant teachers in different schools under district primary council Purbo Bardhaman. They are praying mutual transfer among themselves within the district. Uh, the petitioners are not eligible to apply for such transfer unless their services are declared to be confirmed by the said council. The chairman of the said council, the respondent number not such and such is directed to file a report.
7. Respondent notes.
Effect on the next date of hearing. January monthly. Let it come first. If it is confirmed, then your representation must be here. Your representation must be here.
This is a
Yes, my lord.
tripartite mutual transfer agreement.
Common
25.
representation or
25.
separate. Already there. I will direct to dispose
ma'am.
it off.
My lord, under the heading transfer.
Transfer. Mutual transfer.
My lord, this is a single transfer on the ground of medical and distance. I am presently working in Purbo Bardhaman. I am seeking transfer to Nodia. The Purbo CMOH Nodia, where my house is. There I am being treated by the government hospital and I have the prescription. It's an inter-district. My lord,
Unless
What kind of disease you are suffering?
my lord, if your lordship gynecological disorder, my lord, your lordship, I have the government hospital prescription, page 18, 17 and 18. 17 and 18.
Only in 2021 you have come here.
Joined in July 2020.
Yes, on medical ground, my lord. If
But,
board
that
can
is-
consider me unfit, that this is a ground or condition not fit for transfer, they can do so. But on medical ground, I am in law, I am being allowed to do so.
that is within the
Then
district.
settle the order of this court, the judgment of this court.
My lord.
Medical ground does not. In medical ground, you can apply within time.
Within
That is the
district.
judgment of this court.
My lord, with that law.
Rule does not prescribe so.
Yes, my lord. The new rule, initially, my lord, 2002 rules, your lordship, after kindly see this, thereafter I will place my case, education minister.
ভুলভাল আইন শিখিয়ে দিচ্ছে মহা মুশকিল আছে।
You have been advised to take rest.
And excessive work and journey. The
Who will
condition is, my
decide
lord, I
which
tell
one-
you, I cannot, my lord.
Who will decide which one is excessive?
My lord, excessive, if I travel from Purbo Bardhaman to
No,
Noida.
travel is another part.
Yes, traveling causes excessive, because
No,
teaching is does not,
Taking classes?
not excessive, cannot
Sure.
be excessive.
No, you have been advised to take rest.
My lord, I have been advised to take rest and avoid excessive strenuous work.
So take rest.
My lord, taking rest, I can also advise I can also manage to conduct school regularly, and my conduct in Purbo Bardhaman, your lordship, you can call for. I never ask for CL. I'm regular in class school. It's not that I always, but
Purbo Bardhaman, file a report regarding the attendance and the classes of this teacher.
and if they want, they can also conduct a medical way of the petitioner. I am ready.
In spite of that, the availability of my lord,
My lord,
school-
here, my lord, if
otherwise he is
such thing,
asking for inter-district from Purbo Bardhaman to Nodia. If she satisfied with the requirement, she can be transferred within the Purbo Bardhaman. But when she will be asking to transfer Nodia, then my lord, the availability on people teacher is. So I have prepared my lord's compilation
here,
under
if
that
such-
matter is fixed.
when this submission is being made, my lord, the law needs to be placed. Your lordship knows that 2002 recruitment transfer rule says module of transfer lays down within a district. Within a district, 2002 rule says, but after the 2021 amendment, it says that for with inter-district transfer, the procedure to be laid down in the 2002 rules shall be applicable. Now, my lord, there is an amendment in the 21 rules that in case of medical ground, the 5-year bar will not be a ground, and if the medical condition is satisfied, on the report of the CMOH, if the authority is satisfied, I am going to get a medical transfer. This is the law. They are saying that vacancy is on medical ground. No, they cannot go. The law has been framed by the state. Law has been framed by the state, my lord. Your lordship is.
What is your CMH report?
My lord, page 17. They can also. I am not shying from a again medical test from Bardhaman. From the board, I am not at all shying.
Bardhaman is required. Well, she is working there.
Is it CMH report?
No, it is in Nodia. This is the hospital, my lord, where I regularly get myself checked in the government hospital.
So you go to your native place for medical?
Yes, every Saturday after school hours, I go to my native place, and on Monday morning I come back.
Nowhere is this CMH report is there.
Well, this is government hospital, but CMOH report, but it's a government doctor. CMOH report may be called for. I am saying the rule says it has to be by a government medical practitioner. This is a government hospital.
That is your lordship. After the application for transfer has been considered, CMOH
No.
verifies.
On medical ground, it shall only be considered after there is a medical report that his condition is such that it requires a medical transfer.
But when?
After I will first make an application before the chairman. The chairman will conduct my, if it is on medical ground, the chairman will conduct a medical test by a government medical practitioner. If the report says that my medical condition is
Government
such,
medical practitioner or CMOH?
government amendment. My lord, it is with your lordship 2021
amendment.
2021 amendment.
ফাইলটা দাও, ফাইলটা দাও।
কিন্তু তো বইটাতেও নেই।
পুরো ফাইলটা দাও।
এই কোশ্চেনটা একটু দাও 2000
CMOH, your lordship. The council shall take report from the concerned chief medical officer of health. It's in the amendment of 13/9/2021.
Report from CMOH by
That is within the district of.
আরে ওটা মিটার স্পিড কি এখন বলে দিয়েছে 28 দেখুন।
দেখে নিচ্ছি আমি দেখে
এই যে এই দেখুন। 2002 এর amendment।
আপনি বললে
দেখো মূল্যে
আপনি বললে বেশি অবস্থা আপনি বলবেন।
Which portion you are relying on?
The CMOH portion your lordship wants to see. It is in third page of the 13/9 notification.
এটা দেখলাম people teacher issue is mandatory.
My lord, internal page 3 F.
আরে এই এখান থেকে দেখি।
Your lordship.
Chief medical officer, but no, any other doctor is not competent.
Competent, let it be again checked by CMOH. I have no difficulty.
কোনগুলো amendment হবে?
2002 এর।
পার্টিকুলার কোন প্রভিশন থেকে amend করছে? না ইনসার্ট করছে?
Insert অনেকগুলো 3-4. Your lordship.
Idea report
This
first.
13/9/21 amendment is in respect of the 2002 rules. This 2002 rules is in respect of transfer between two schools within our district.
My lord, rule 8.
But rule 8 has been amended.
Rule 8
Not rule it while considering inter-council transfer in accordance with the provision of clause K 19(1) of the board shall stand.
If I say this,
But
follow the provision of
in
the
the
rule.
same way, just I was asking Mr. Laidi, then how can you reconcile Rule 1
Sir, I am giving this answer. I was there, my lord. My lord, your lordship knows CPC. The procedures and the law laid down in CPC, my lord, are the principles of that are followed in writ proceedings. Similarly, my lord, it's not that the 2002 rules, when it was framed, it was considered only within districts, the chairman within the same district. But for intra-district, since it was said that the procedure to be followed by the chairman or the council in respect of transfer should be the same in respect of inter-district council. That is what, my lord, that is how it has to be reconciled harmoniously, taking into consideration the intention of the legislature. Intention of the legislature is,
First of all, why 21 was needed?
21 was needed, my lord. I tell your lordship, initially it was all offline where thing was there.
Fitting Uchosri.
For fitting Uchosri, it was introduced. This is the only
Right?
reason.
To fit in Uchosri. So why 8 was amended? So that in one portal, inter or intra can be looked into. So 8 was, in other words, the sub rule 2 was not taken care of, or the procedure and practice already prescribed under 91 notification, that was also not taken in. 91 notification has a special feature. Why? At that time, 2001 rule was not there.
Not there.
2002 rule was not there. The only thing was a procedure and what it is called, first part is
practice and
procedure. These are and it is notified under the original section 19(1)(k)
of the 1973 Act. But my
itself.
lord, a notification is something, my lord, in pursuant to an act. My lord, if I am correctly understood, 91 notification is pursuant to 1973 Act. Thereafter, my lord, 2002 is pursuant to Act. Now, notification and a rule is being placed, my lord. Rule has a higher effect, my lord. Rule will override acts, those notifications, because those are not placed in the legislature, my lord, but rules have to be placed and it has to be laid down.
Mr. Dasgupta, here lies the problem.
Rules have to be laid down, but notifications are not required.
Prescription. This is the prescription of the statute.
19(1)(k).
This is not required to be rooted to the way an act is legislated. The act gives a power under the act to the subordinate or to the administrative part to frame rules.
Yes.
It is a prescription. Therefore, the power which has been derived so 19(k) is specific power conferred of powers of the function of the board upon the board. Specific power conferred under this statute upon the board. The board has prescribed a procedure or a practice. This is the followed. Then what is the difference? If it is even said, it may be termed as practice and procedure. In effect, he is prescribing a procedure to be adopted for considering the inter-district transfer. What is the difference between rule and this procedure?
My lord, at that point of time when 1991 notification came pursuant to 1973 Act.
Dasgupta, react after understanding what I want to say. A rule framed under by deriving power from a statute, because rule making power must be given instead of framing it in the form of a rule. The authority which has been vested with the power to frame the rule, it notifies some procedure. What is the difference between these two?
19(1)(k), my lord, kindly come.
You see,
Transfer. What is 19(1)(k), my lord?
this is the power and function of board. One of the
19(1)(k)
powers
Power and functions of the board and the president.
is one of the powers of the board of the
What is the
president.
power, my lord?
What is the power?
19(1)(k) to transfer any teacher or non-teaching staff from a primary school within the jurisdiction of one primary school to a primary school within the jurisdiction of another primary council. This is the power which the board vests pursuant
First,
to
you
the
understand what is rule.
What is rule?
What is a rule? The superior or the rule making power must be vested with the authority who is that must have the statute recognizes the power rule making power. Particular section gives a rule making power to an authority. What is rule? Rule prescribes that these are the procedures. Supposing this should be the form number 1 prescribed under the schedule of that rule. Instead of saying it as a rule, if the authority who has the power to make the rule announces that we will follow this procedure for the purpose of inter-district transfer, can you brush aside that saying, oh, it has not been termed as a rule?
My lord, may I give my respectful answer, my lord? First, this 19(1)(k) deals with, section 19 deals with the powers of the board. One of the power is to effect transfer within one district to another district. This is a power given to board. For implementation of this power, board on its own, for its own accord, my lord, has framed a certain guideline, I will say. I will not even say it's a notification. It's a guideline to function.
What notification? It's a notification.
It's a notification. my lord.
Notified.
It's a notification. So that notification has been framed so that the power given under section 19(1)(k) can be implemented.
No. Let you put it in another way. A rule-making power is vested with this board. Now the board has to act, board has to implement this. Board can prescribe the procedure that I will follow this procedure to this. It may be in the form of a rule, it may be in the form of a notification. The rule should be written in this form, nowhere it has been written. Now, if you go by this, the how, where is the difference between why are you rather ready to accept it as the all trappings of a rule? What is saying? The following the principles and procedure for transfer of a teacher or non-teaching staff of a primary school within the jurisdiction of one primary council to a primary within the jurisdiction another primary council set up by West Bengal Board of Primary for the purpose of clause K subsection 1 section 19 of the West Bengal Board of Primary Education 1973.
For the purpose, my lord, kindly mark the word for the purpose of section 19.
Now come to the rule. Now come to the rule.
2002 rules.
Come to this 2002 rule.
And it has not been gazetted, my lord. Kindly consider also that. Not been gazetted.
Come to this
2002 rules, my lord.
Come to 2000. In exercise of power in subsection 1 clause K of section 2 of 106 of the primary education such and such. Difference is this rule making power is under section 106.
See
that rule making power
anything made beyond 106 cannot be considered as a rule.
That is what you must say.
99 in one gazette.
Yes. Therefore, this has got maybe have a trappings of that. Since this has not been framed in exercise of power under 106, therefore you may very well say, but the procedure, in the absence of two, in the absence of 2002, in the absence of 2001, 91, board thought it expedient that we should lay down, we should follow a procedure for this kind of transfer.
But my lord, when the legislature expressly prescribed a rule for the same, the latter one automatically.
No. First of all, in 2001, consciously exclusion in subsection 2 of section 1, conscious exception, exclusion of inter-district transfer. But in 2021 amendment, only to fit in Uchshosri, 8 has been amended, bringing application of this 2002 rule mutatis mutandis in respect of inter-district transfer. Right?
My lord,
No
only one
dispute
thing,
with
kindly
regard
come to the old rule 2002.
No, there is
No
no
dispute,
dispute.
no dispute.
Dispute with regard to this
Yes,
position.
yes.
Now, fact remains, either you scrap this procedure and practice, scrap this, go by 2002 rule only as it amended after 2021.
My lord, I will only one kind, old 2002 rules. Old 2002 rules kindly come to rule 8.
2001 rule.
2002 rules. I am saying 2002 rules.
Old, before amendment.
Before amendment. My lord, your lordship has this.
8.
Rule 8, my lord. I am reading, my lord, for your lordship.
191K.
My lord, I am reading. What I am trying to establish, my lord. In case of inter-council transfer, the council shall follow the principle and procedure of the board in accordance with the provision conferred by clause K of subsection 1. So, my lord, before 2021, if there is any inter-council transfer, that procedure and practice of 1991 was to be.
That gets recognized by this section.
2002 rules?
2002 rules 8 of the is
recognizing, my lord. Now, my lord, consider the amendment. This has been omitted. So
omitted means it has been taken another shape.
Another shape.
That means that this is no longer required.
No longer required. Now that procedure cannot be relied upon, my lord. If the legislature expressly does something, my lord, with deepest
now,
of respect,
now show me inter-council transfer. Inter-council, what is the which procedure is to be followed in 2002?
In 2002, my lord, after amendment or before amendment?
After amendment, obviously.
After amendment, my lord, the procedure laid down in these.
Show me what is the procedure. Then that procedure suggests that this council will file a report. This council will take into consideration. Then both the council will send their opinion to the board. Board will act on the basis of these two opinions. What I am doing over here, when you are coming for mutual transfer in two districts or any other inter-district transfer, I will certainly ask X district council, file your report whether it will create any adverse effect on the learning board. Similarly, the same question will put to the other district council where you want to go, whether you can accommodate him. These are the two exercises.
In case of mutual transfer, that question does
not mutual transfer.
In general transfer.
In general, this is to be done. Without that, nothing can be done.
Yes, nothing can be done.
Nothing can be done. Even if your representation is relegated to the board, what the board will consider? Board will ask the same question to the council where you belong, that whether if I pick up this teacher, whether the students will suffer. And he will ask this council that can you accommodate this teacher if I send it to you?
Yes.
Yes, Madam.
So this procedure has been nicely grafted in that 91 prescription. If this has been approved, that Shosri has done the mischief for everywhere. Now, if you totally throw it to the anywhere, but the same exercise you have to do. Otherwise, you cannot do.
Your lordship is doing the correct thing, calling a report from the chairman, my lord. But only thing.
But this is not the task of the court.
This is not the task.
This is the administrative task. The prescription must be of such
nature.
But where is show me that 2002?
If the legislature has omitted it, you cannot rely upon my lord, the board.
Mr. Dasgupta, it is very easy. If it had there been a so easy a thing, just apply it. This will apply to that also. Have you the mind to see when there is an inter-district transfer, where is the scope for consideration of the requirement? Where is the consideration of that that person, if is withdrawn from that, what would be the effect on that?
Yes.
Which was absolutely and clarity, very clearly laid down in the practice and procedure. You see, mutandis apply. If the provision is there, then mutandis apply. Provision of order 41 will apply, mutandis in order 47. It is very easy, very well, because it's the same thing. Your memo of appeal
And
is
review.
replaced by memorandum of review. But where is that thing here? Show me. And that is why in the morning I asked the Advocate General, please reconcile with this. It is not that court, when the law is framed, court will look into that, whether it has been properly implemented. I am here not to legislate.
My lord, only thing what is falling from your lordship, normal procedure would have been, suppose my lord, in this case, let us take this case. I am working in Purva Bardhaman, I am want to go to Nadia. I have made an application to Purva Bardhaman. What Purva Bardhaman will do? First, they will consider whether I am medically entitled to. If they found that I am not medically entitled, at the
Mr.
threshold, my
Dasgupta,
application
possibly
will
his
be.
task is not only consider your convenience, inconvenience.
No, convenience.
His first task is whether this teacher, I can consider his prayer in the backdrop that what will the effect on the student. Then the secondarily comes whether I can use this teacher can at all come here. What are the inconvenience she would be facing? First thing is to consider, if I leave this teacher, what would be the student's inconvenience? That secondary it will come. These are the all factors. You cannot restrict the inquiry on your inconvenience only.
But my lord, with I am
May I just indicate one thing?
opportunity, my lord, but only one thing.
Lordship has correctly, my lord, observed this. After 2010, when the RTE Act came into effect, my lord, all notifications by state and other authorities, my lord, has issued this, my lord, keeping in mind the provisions of RTE Act. And this RTE Act, my lord, Right to Education Act, my lord, strictly says that one must maintain the pupil-teacher ratio under any circumstances. Now, the difficulty, my lord, in a inter-district transfer, unlike intra-district transfer, is that, my lord, one must be accommodated. Someone will, my lord, leave his school, leave his or
That is
her
what
school.
I am saying. And
Exactly.
another has to do.
Exactly.
Two
That is why-
considerations will be
Yes.
going by side.
So
Now, you cannot just pose this, that you are here to consider my inconvenience. You are here to consider that whether I am actually suffering or not that. The primal consideration of the chairman or the DPSC is whether your prayer can at all be entertained, because it may a collateral damage would cause to the students.
My lord, I bow down to your lord only one thing. If it is a transfer within the same council, if it is a transfer within the same council, my lord, let us take a case, my lord. A transfer within Purva Bardhaman, a teacher is working in A school, he want to go to B school.
Then again, whether B school requires you,
My lord,
whether
my
A
lord, I
school
am-
can afford to leave you.
My lord, I am kindly petitioner is working in A school in Purva Bardhaman. He wants to go to B school in Purva Bardhaman nearer to her residence on ground of medical emergency. This is a ground for transfer. My lord, what the chair council would do, according to me, in terms of the act, they cannot go beyond the rules. In terms of medical application, the first thing council is required to do is, according to the act I am saying, they have to first check whether the grounds set forth in the rules, medical grounds, whether I am covered by those medical grounds or
All
not.
this between the lines underlying is interest of the students.
With deepest of respect, my lord, your lordship is correct, but that is not laid down in the rules.
No, not so many words it required to be written.
My lord, when
The
a
transfer rules is for the
benefit of the teachers, my lord, not for the
in
student.
larger respect, employer has every right to deploy its force wherever it is required. Of course, for deployment, it must not be a punishment. Secondly, for deployment, a humanitarian approach should be taken. It does not mean the original object will throw away and will only consider the concept, the interest or the inconvenience of the employee concerned.
Another thing, if that be the case, if that be the case, transfer is a matter of right after the act. Yes, I humbly submit transfer is my matter of right after if there is an act. If there is no act, I have no right. And secondly, my lord, if that be the case, I absolutely agree with your lordship that the primary consideration should be the student. Then also in case of administrative transfer, nobody is asking the students that if teacher is transferred on administrative ground, what is the effect of that transfer?
No, even in the administrative.
No, it is not done.
Mr.
Let them say.
Dasgupta, administrative transfer also. This cannot be arbitrary.
Yes,
The
cannot be
arbitrary-
arbitrary. Has
Now
they
today
taken
the
anything?
position is, I'm before my court, I'm telling you what is the position of my court. If I got these surplus teachers, the council, the chairman is bound to issue administrative notice for transfer of those surplus teachers.
Of those surplus teachers, now my lord, I put this question to myself.
Now,
then
Mr.
the
Dasgupta, what
council
the
will
problem is,
also have to
here
ask
the
that if
problem
those
is,
teachers,
in this sector, the problem is, as you have said, and with the rather conviction, that is a matter of right. No one is bothering these books, these rules for whom? For whom? For those who are in the school. You cannot expect that you will take transfer and the children will not be getting a teacher for which you have been paid every month.
appropriate authority of the legislature to think like such. If there is a rule, let this rule be obsolete. Let
No,
this
no,
rule be
rule
omitted. No
says that
transfer.
you can apply on medical ground. Let us understand.
Yes.
Of course, it is giving you the right to apply. But while considering that, it is when nowhere it has been written that the interest of the children would not be looked into, only the interest of the teacher will be looked
My
into.
lord, can we, in deepest of regret, can we read what is not in the rules? Can
What
we
you,
read
what you are, tell me what you are expecting.
My lord,
The rule will say that first you consider whether the teacher, don't
that is-
expect.
yes, it is written in the rules. I am telling you, love. If your lordship amendment rule dilam kaka একটা দেখছি। in case of transfer which is not on medical ground, it is stated that for transfer other than medical ground, pupil teacher ratio has to be seen. Any other factors are to be seen, whether that teacher is performing everything.
Possibly RT Act spirit has not been laid down. RT,
2002, then there was no RT Act.
now after this RT, this is a mandate. That is why last occasion, Mr. Sannal, he was not given the total. And I don't know, all of you have done this kind of matters. But why don't you think about that? This practice, procedural, all these things. This was not been given the understanding neither to the court nor the council. Unfortunately, I'm bound. I really, I do not want to say all of you are very big advocates on this field, but you did not see that what as the rules have been, the rules as it is taken a shape only to fade the Rushosri, to provide some
My
benefit
lord,
to the teachers.
3AC, what is falling from your lordship? I have said, my lord, 3AC of the amendment rules. Kindly see. It talks about pupil teacher ratio other than medical ground.
No, when this was taken,
21.
then it has failed to take into consideration the spirit of RT Act. If it is so, I should struck it down.
My lord,
This
in
is failed to-
Act, my lord, has been framed, my lord, in terms of Article 21 capital A, which was incorporated, my lord, in
Impossible.
2002.
So far the primary education is concerned, all rules, all act, every legislation, the underlying thing is all actions taken by legislature to protect the children. To protect the children, no one else. No one else. Now, is it, I want to get, my view is, yes, this teacher is suffering. If I put him nearer to his house, I can get the best of her or best of him. This is for the interest of the student. This is not a right of that teacher that I am suffering, therefore take me nearer to my home. The object is to take the teacher nearer to the school, is to get his best service or maximum get the output.
My lord, as it fell from your
The
lordship, there are
concept that I
surplus
have to work from my home, malad, that should go. I have to take a home near my school, and that concept must be adopted. my
No,
lord.
no, that is why when I was taking the secondary matters, possibly
Several
I highlighted forgo your house rent allowance, forgo your house rent allowance. You are getting house rent allowance, and you will be saying, I will not go to the place. I would like to take my test. And all these rural areas schools are crying. Now in the morning, I found that you moved it 1,100 students in a primary school. Number of teachers, only 3, 1 para teacher. And in the same district, you will be finding teachers in a school, per school, 2, 3 surplus
My lord,
teachers.
for this, who is responsible, my lord?
No, of course. Responsibility is everyone.
No, not of the teachers, because appointments are being given by the council.
They only see what?
There has to, no, kindly consider one thing.
Very
What in
unfortunate.
primary school, I tell your lordship, in 1 year, in one academic year, suppose, my lord, there are 100 students. In the next academic year, your lordship might see there are 30 students.
Mr. Dashgupta, I have seen some schools where the secondary section and primary section has a tussle. Don't admit students.
That is in Howrah, my lord. I know.
I'm telling you,
Very famous
there
school
is a
in Howrah.
tussle between the primary section and the secondary section. They are literally fighting. Don't take student admission of the students, because the RT mandate is that in the in-house you have to cater the students of primary section in the secondary section. The secondary section is crying, how can we accommodate this much? We have to take some good students from outside also.
And nearest school is no student.
And the nearby school is no student. So
My lord, in-
overall holistic view is to be taken. It is difficult for teachers to take into account. It is difficult for taking into account. Even the court can do what when the matter will come? I can shout at least. But if the
what is
legislature,
falling from your lordship, the concern is absolutely, my lord, right, my lord. The primary consideration should be of the students, my lord. But if
there is no dispute with the interest, there is no dispute, Mr.
but my lord,
Dasgupta,
the
with
difficulty
this interest of the student and the interest of the teacher, because the ultimate object, that teachers should be taken the service of the maximum service of the teacher.
my lord, if suppose one,
But
there is a
it is
law, my
very
lord,
unfortunate.
my lord, we are in a professional. Suppose, my lord, there is a law is enacted by the parliament now that whoever is enrolled as an advocate, irrespective of anything done, he will get 1 lakh rupees per month, irrespective of anything. If that be the so,
That is coming.
my lord, never in dreams also. If that be the so, I tell your lordship, I will not work. Clients will come, I will not do your case. This,
Possibly no advocate can do that. They will die.
no. There is a right now 1 lakh rupees I am getting per month. Similarly, when a teacher says,
Those who are
I have a right,
advocate,
I have a right.
professionals, they cannot leave. They
No, no,
cannot.
that
It
is-
is a curse.
Please,
I'm telling you.
the example given by Mr. Dasgupta,
This will be a curse.
law of marginal demolition is not
According to
Yes.
inflation, that will increase.
But
My
Mr.
lord, only one
Dasgupta,
thing-
so long I will be taking, just keep aside all your ideas regarding
No, no, your
transfer.
lordship is right.
Transfer is for the benefit of those
My lord,
children
only
in
one
the school.
thing. My lord,
I am
only-
answerable to my posterity. If I endorse to this view, it is your right.
My lord, only one thing. There are 30 students and there are 5 teachers. Let us take a situation in a school. Requirement is 1.
4 will go.
4 will go. Now, it may happen, my lord, one of those 4 teachers in a junior strength, they are surplus. It may happen one of those amongst those 4 teachers, one teacher is so good and she or he is very famous among the students because of her way of
course.
teaching. Then, my lord, at the even by way of administrative transfer, then the council will also have to take the opinion
Of the
that
children.
but that is not being done and
Let
nobody
us
is
see,
saying-
let us see, think about the very ideal condition when the children will be asked amongst them whom you want. You will be here. No one will be there.
I can
Mr.
tell your
Dasgupta, the
lordship-
children are very intelligent. I'm
I
telling
can
you.
tell your lordship is
Child suffered.
my lord.
After adult suffered, child suffered.
Yes, off, make it off.